this noise. Good afternoon, everyone.
Okay.
Good afternoon, Ashwini ma'am.
Good afternoon, sir. One second. Yeah, I am visible as well as audible.
Yes, ma'am. Perfectly visible and audible. Could you also try sharing your PPT once, ma'am? We'll check once.
Yeah. Okay. So is it fine?
Perfect, ma'am. Thank you.
Okay. Yeah.
Good afternoon, everyone. Welcome to the Section 2 of Impact Lecture Session sponsored by MHRTS Innovation Cell AICT New Delhi. Now, the afternoon session is about patent law. Now I call upon Mr. Pawan Kumar, Assistant Professor, ECE Department, to give the intro about the resource person. Welcome, sir.
Thank you, Nisha ma'am. Am I audible to you?
Yes, Paul, you're audible. Please go ahead.
Yeah, good afternoon to all the delegates, participants from various reputed institutions who are attending this Impact Lecture Series 2 sessions. I hope you all had a delicious lunch, and to continue with this, we are about to experience more delicious session from P. Ashwini Pai ma'am. And it's my privilege to read the profile of Ashwini ma'am. So coming to her educational background, she completed her undergraduate in B.Pharm at E.T. Gulabi Shetty Memorial Institute of Pharmaceutical Sciences, Mangalore, and she pursued her post-graduation at M.Pharm at Srinivas College of Pharmacy. She underwent practical and technical trainings at Swadeshi Ayurveda Bhandar and Sequent Research Limited, Udupi and Mangalore locations. So coming to her key achievements, she held the Best Academic Performance Awards for the 2 consecutive years, 2013-14 and 2015. And at the second year of M-Pharmacy exam, she secured a university second rank in these examinations. She also attended many workshops and conferences related to research and IPR. So coming to her working experience, she started her career as assistant professor in Department of Pharmaceutics at Srinivas College of Pharmacy, Walshil, Bangalore. She worked as an women scientist trainee at Patent Facilitating Center, IFAC, DST, New Delhi. She acquired knowledge and gained skills in the IPR during this training period, and she was also qualified in patent examination in 2018. And in the process, she received 25,000 as a cash prize for her excellent performance. Later, she worked as a project manager related to IPR and created student startup policy and innovation policy cell at Gujarat Knowledge Center, Gandhinagar. Currently, she is working in Niche College of Pharmaceutical Sciences, Bangalore. With this, I came to know that Ashwini ma'am is rich in knowledge and skills in IPR. So with this, I thank you for this giving this opportunity to read the profile of madam. And I'm handovering the session to Ashwini ma'am. Now the floor is yours, ma'am. Welcome.
Thank you, sir. Okay, that one, please unmute me. Am I audible?
Yes, ma'am. You can continue.
Okay. Yeah, first of all, thank you so much, sir, for giving a very kind introduction of mine. So it is my privilege that I have been invited as a guest today for talking on this topic, patent law, which is a trending topic, I would say. So thank you once again for this very kind introduction. So let me now start with this presentation, that is the patent law. So patent is a very important concept either in the research or in the industry or even in academia. So let's see how this patent law is, how we can apply. So I will briefly discuss regarding the basics of this patent law in today's session. So firstly, there is a law or a legislation that governs, okay, the patents in our country, and that is given by the Patent Act 1970. So first of all, we must know what is a patent. What is a patent? So that is a very important question. So it is a exclusive rights that is granted by the government to the inventor to exclude others to make, use, sell any invention in a specific period of time. So this is a specific definition which is given as per this definition is as per the Patent Act. As a definition says, it's an exclusive right. What is exclusive right? Exclusive right is a right given to one particular person by the government. So it's a statutory right, and the statutory means this right is given by the government and it is a territorial right. Suppose if I am the inventor, so and I file a patent, the patent office will give the rights to me exclusively to me, and this right I can employ it anywhere in India. It is applicable within India, so it is also called a statutory right. So patent is an exclusive right granted by the government to the inventor. What is a need to file patent? So if you are not filing the patent, then it is absolutely like your invention, someone may take it very easily, or like someone may copy your invention, or you are the it's your idea, your product, but somebody else will take advantage of it and they will make money out of it. So to prevent all this, patent plays up, here is where the patent actually plays important role. You file a patent, then you get the exclusive right which is granted to you by the government, and you can protect others from making, using, selling your invention for a specific period. And this period is 20 years from the date of filing. Suppose today I am filing the patent application. So from today, in case my patent is granted after few years, then I can execute that rights, or I have that rights, and I can generate income out of it, or I can use, make, sell that my particular invention for about 20 years from today. Okay, I hope this basic definition of patent is clear to you all. So who manages this law? So as it's a government agency, that's Office of Controller General of Patents, Designs and Trademark, or also called as, it's a famously Patent Office. So this is an agency under the government which administers the Indian law of patents, designs and trademark. Then there are 4 offices in Kolkata for East region, in Mumbai for West region, Delhi for North region, and Chennai for the South region. So if I am from Karnataka, so I will have to apply for the, I will have to give the application for patent in Chennai. So that is the, it is zonally, it has been divided, these patent offices, and these are in 4 locations, as I told earlier. So now, before coming to the patent, you must know what is an invention. So what is an invention? So any invention, it's a new product or a process involving an inventive step capable of the industrial application. So a patent is granted. You can file a patent for either a product or a process. For example, a product may be a mobile phone, okay, or a new device that you have invented. You can file the final product or the process. Suppose the process of making one chemical. There are numerous steps involved and that only you know it. So either you can file the patent for the product or for the process, but it should involve an inventive step. This is very, very important. So patent is given for any invention that involve technical aspect or an inventive step, and also it should be capable of industrial application. Industrial application in the sense it should be useful. Simply come up with invention, but it doesn't have any use. That's of no use. So any new product, an invention is a new product or a process involving an inventive step and that is capable of an industrial application. So for example, I want to discuss this regarding two types of the patent. So one is product patent and one more is process patent. What is product patent? So product patent is generally given for the products. So nobody else can manufacture, sell, or generate revenue for the product that you have invented. Even by suppose you can, for example, you can consider this powder. Suppose this is one ultimate final product. So if I file a patent on this, nobody else can make this product. Even if it ends up with the final chemical product through some other process, even then he cannot sell this product. Whereas process patent is given for a particular process. Suppose I have a chemical on the right hand side. So this chemical is made by particular process. So I can only get the patent for the new process. Okay, but it does not bar or prevent others from manufacturing or creating the same product by distinct process. So this process patent is called as limited product. It gives limited protection. Always it is better to go for the product patent than the process patent, because product patent will give you more protection when compared to the process patent. And usually we prefer writing the invention or writing the claim in such a way that we give protection for both the final product as well as the process. Product by process claim is a product claim that defines the claimed product in terms of the process by which it is made. So you are protecting your process as well as the product. So as per my opinion, always the product patents, if you are very much bothered about the monopoly, then product patent is very, very important. So we will discuss the various concepts of this patent law, like criteria for an invention to be patentable, what can be patented, who can file a patent, steps involved or process of filing a patent, anticipation, types of patent applications, and opposition of the patent in our session today. So first, coming to the criteria for an invention to be patentable. What are the criteria? So first and foremost, the basic criteria is the invention should be novel. Novel means what? Novel is, it should be not known to the public. It should be non-obvious, or it should not be published anywhere. It should not be a prior art. No one must know. It should be totally new, neither published. Even if you have idea, you came up with a device, but you published it somewhere, maybe in papers, or you want to, you disclosed it by making a video in the YouTube. Your novelty is lost. You cannot file the patent then. So novelty means the concept that you have made or invented that is totally new, not known to the person skilled in the art, or the person who is working in the current technology. He must not know it. So novelty is simply that invention should be totally new and non-obvious. Neither it should be published either in the research papers or whatever. It should not be made known to the public. Next is inventive step. So what is this inventive step? So inventive step, as per the Patent Act, it has a definition also. Inventive step means a feature of an invention that involves technical advancement or having economic significance or both, and then makes the invention not obvious to the person skilled in the art. So see, there are three important things. Any invention that should involve, inventive step means it should involve some technical advancement over the already existing work. Already some invention, any suppose this bottle is normally available. Okay, you have to make it some extra technical feature you will have to add into it. Okay, then only it is patentable, else no. And also it should have the economic significance or both, and it should not be recreated by the person who is skilled in the art, or it should not be easily made by the public. So, but you are once you are drafting the patent application, you are going to disclose totally the invention in that. So that time you are going to reveal what your invention is to public, but prior to that, it should not be disclosed anywhere. And third one is industrial application. Industrial application is the product, whatever you make, it has to be useful. Moreover, you should be able to create that product. Just writing that your product is useful, that doesn't make any sense. You should be able to make it as well as use it. So these are the three prime criteria for an invention to be patentable. It should be novel, it should have an inventive step, and industrial application. Then coming to what can be patented. So what are the things that you can patent as per the Patent Act? So before coming to this question, it is very important to know what are the things that cannot be patented as per our Indian law. So what cannot be patented? So this is explained by section 3 and 4 of the Patent Act. So section 3 and section 4 of the Indian Patent Act 1970 clearly explains what cannot be patented, or inventions that are not patentable, patent subject matter that are not patentable as per the Patent Act. So let us see one by one which are the inventions that are not patentable. So first, the inventions that are frivolous. Frivolous, or which claims anything obviously contrary to the well-established natural laws. Frivolous or obvious, or whichever invention is contrary to the well-established natural laws. See the example: a machine claiming 100% efficiency, or a machine claiming for giving the output without taking any input. That is practically not possible. You cannot make a machine without giving any input only. You cannot get the output, so that is not practically possible. Suppose if anybody comes with the invention that suppose energy drink, he claims that this energy drink, if you drink for 5 days, you can run like Usain Bolt. Or if you drink this product, then your weight will be gained by 20 kgs within 2 days. So these are all practically impossible things, and it is against the natural laws. So any inventions which comes under this category is, or such type of inventions are not patentable. So next type of invention which is not patentable is an invention which is contrary to the public order or morality, or which causes serious prejudice to human, animals, or plant life, or health, or to the environment. So anything that is against the public, okay, or the health of the public, or against, you are creating some problem, havoc in the public, such inventions is not patentable. For example, if you are coming with the machine used for performing the theft, you are helping the thief to carry, your invention is such that you aim is to help the thief to carry out the theft. Such invention is against the moral laws. So these inventions are not patentable. And also any device or a machinery apparatus which assists the counterfeit. This is the example I am giving for printing of the currency notes. So you cannot devise such invention, or such inventions cannot be protected under this patent law. And also gambling device or machine. So here you can see that this is a Dettol. See, even in Dettol they write kills 99.9% of germs without water. So nobody will claim it gives 100% efficacy. So it's like that. So next, let's see. That is any invention, the mere discovery of the scientific principle or the formulation of an abstract theory, or the discovery of any living things, or non-living substance occurring in the nature. Mere discovery of scientific principle, already that is existing in the nature. So any invention, okay, any discovery is not an invention. So you went to some garden, okay, and you found a new type of flower which is not at all recognized. That is not an invention. That is just the discovery of the existing thing in the earth. Okay, or you come up with a new type of animal or a new animal you found. Okay, you did not see it, then it is not patentable. Or either principles like Newton's law, this is already known. You can use this law and devise when something new equipment, that is possible. But as such, these principles, laws, and these are all not patentable. Simply the mere discovery. Discovery can never become an invention. You have to remember this concept. Discovery can never become an invention. So this is an example you can see. For example, microorganisms, which was occurring freely in nature. So it is by nature, from the nature it is. You haven't invented it. It has been discovered. So discoveries cannot become the inventions. So next. So this is very important, especially for the people who are dealing with the chemicals. So mere discovery of the new form of the known substance or the new property of the known substance, new use of the known substance, or new use of the known process, machine, or the apparatus which already exists, unless the process will result in the new product or employs at least one new reactant. So this I can explain with using this famous, I think everyone have taken this vaccine, that is Covishield. So see, this Covishield was, it came out when during this COVID pandemic. So now, after a few years, we know that this is a vaccine for corona. Now, after a few years, like some scientists will claim that, so I can use this Covishield for treating cancer. Suppose he claims it. This is hypothesis. Probably it may not happen also. Just I am giving an example. A new form of the already known substance is not patentable under the Patent Act. Either it is a new form or a new property. So this example is for new property. It is used for as a vaccine prophylactically for corona. But if somebody claims it can be used for cancer, so it becomes a new property of the known substance. So such type of inventions are not patentable. And this is one more important concept. So a substance obtained by mere admixture resulting in only the aggregation of the properties of the components thereof, or a process for producing such substance. Suppose what does this mean is, suppose I have A and B. I have A plus B. I have two chemical substances. I mix A and B, and finally the result what I get, it is not synergistic. The action what I get is same again A plus B only. This is not patentable. The substance obtained by mere admixture, by mixing two substances, and again it will result only in the aggregation of properties. This is also related to the chemical, the pharma field, this section 3E of the Patent Act. So this mainly says that if you are mixing two substances, then it should result in the synergistic action. That is A plus B, but you are getting the resultant action C, which is much greater than that produced by A and B. So such inventions are patentable only if by mixing two or more substances, the resultant substance should give the synergistic effect. This term is very important. Admixture resulting in the synergistic properties. Then next is mere admixture, mere rearrangement or arrangement or duplication of the known devices, each functioning independently of one another in a known way. So suppose we know that fan also exists, even the electric bulb, okay, or any tube light, it exists, or any way of lamp or anything, it exists. Now somebody comes and claims that, so I have designed a new model of the combination of fan as well as tube light. So fan as well, if he claims in that way, then such inventions are not patentable. Such inventions, so you can see this picture. So this is a product, final product. This is not patentable. It is just, even we know fan, even we know this lamp. So it is just clubbed. So this doesn't become an invention because it's an arrangement or rearrangement or duplication of the device. So it comes in this category. Now, next is a method of agriculture or horticulture. So any method of agriculture is not patentable in India. Method of agriculture or horticulture. For example, plant manufacturing method or a method of generating mushrooms, a method of cultivation of algae, etc. Then this is one of the, this is related to the medical field, a method of treatment. In general, we call this section 3I as the method of treatment. In India, any process of medical, surgical, curative, prophylactic or diagnostic, therapeutic or other treatment of human beings or any process for a similar treatment of animals, method of treatment is not permissible in India or it is not patentable. I can explain you with this example. For example, medicinal methods, administering medicines in a medicine process orally, like it is a method. So I can change the route of administration and I can say this is a new method. No, any medicinal methods are not patentable. Next is surgical method. Surgical method, any method of performing the surgery, cataract operation. No, it is not patentable. Curative methods for cleaning plague purpose. Prophylactic methods, vaccination methods. This is not method. Okay, see, direct the drug formulation can be patentable, but how to inject, how to give this product is not patentable. Even the diagnostic methods like X-rays, blood diagnostic process, all these are not patentable in India. But it is not same in US. In US, this is possible. You can file patent in US with respect to the method of treatment. And this is one more 3IJ, that is animals as a whole or part of the animal. Seeds, plants and varieties of the species of the animals or plants. Biological process for production or propagation of plants and animals. These are not patentable. Suppose you have this, for example, you can see a sheep here. You can see the sheep here. So if you have heard about Dolly, it was a cloned sheep. But in India, if you are going to use this cloning and you are going to come up with a new variety of the animal or plant, then this is not patentable in India. But a microorganism, the one that is genetically modified or which involves the human intervention, such inventions are patentable in India. Okay, so the thing is, human intervention is there for the, if you are genetically modifying something, then that is patentable in India. As such, animals, as such, plants, this animals is especially in this case. Such see this Dolly, but it is not possible in India, cloning and all. Next is a mathematical or business method or a computer program per se or algorithm. So mathematical model, okay, or even the business method. Suppose today I come up with a new business model and say that you employ this model in your company, then you can earn triple profit than what you are earning. So I designed this method, then it is not patentable. Computer programs, these come under copyright. You can, or apps, you cannot file a patent for it, but you can get a copyright over it, and even the algorithms also. So for all this, you can go for the copyrights, especially this computer programs. Then literary, artistic, dramatic, musical work. So you can, if anybody is performing and that event is recorded, or today I am speaking in front of you all and the recording is going on. Okay, so it captures my expressions, my way of explaining. So that is my copyright. I can claim it as my copyright. So literary work, anything related literature. Suppose you are writing a poem, okay, and you are having the right over it. Okay, just by putting C, okay, or you're writing your signature name, so it becomes yours. Okay, so computer programs and even this music, so sound recording, paintings, drawing, architecture, photographic works, these are all coming under the Copyright Act and it is not patentable. So patentable is only for the inventions that involves technical step, okay, or technical concept is involved in the invention, then only it's called invention. Technical advancement should be there. Then next one is a mere scheme or rule or method of performing mental act or method of playing games. Now I came up with a new method of playing chess. Then it is not patentable. Okay, or teaching method or a method for learning. So any methods, you are using your mental capacity and you're coming out with a expression, you are expressing it, then it is not patentable. Suppose this cards, what you play, this cards, it has 52 cards. Okay, that game when you play, suppose you have designed it in a new way. You came a new way of playing this card game. That is not patentable, but you design a card in such a way that the user, when he uses the card, when he holds the card, it becomes easy for him. So you are solving some problem. Some technically concept you are including and you are getting a solution for it. That is patentable, but the game itself is not patentable. Then a presentation of information. So any presentation of information. So either you get a 100-year-old calendar or a railway timetable that existed from so many years, which is already existing, which is known. So all this piece of informations, or even I am presenting today, whatever I know regarding the patent, that is not patentable. This is my expression. So I can copyright this, but I cannot patent it. The slide what I am presenting, it is my property. It's like that. Next is topography of the integrated circuits. So these designs of the circuit, it cannot be patentable. So for this, there is separate law, that is Semiconductor IIC Integrated Circuit Layout Designs Act 2000. It is not patentable. Next, an inventions which in effect is traditional knowledge or which is an aggregation or duplication of the known property of traditionally known component or components. So some medicines are neem, this turmeric, we all know it, tulsi. There are medicinal values. So these have medicinal values which is already known from our ancestral time. So nobody can file patent over such knowledge which is existing from thousands of years. So such type of, you come out with a new variation in this using haldi, if you are coming out with the new tablet, okay, which will increase, which can be easily absorbed in the body, then that is an invention, it can be patentable. But as such, I cannot file patent on haldi or something new that you have discovered it now. It was already existing in the past. Such traditional knowledge or any information or duplication of that is not patentable. So then yeah, one more point is that patents are statutory rights and territorial. These are territorial. I have explained what is this statutory right. This is a right given to the inventor by the public, and territorial, like I am filing the application in India. So I am filing as per the patent law of India. But it is this patent which I get here, that doesn't mean the same patent I can, I file patent here, but US does not consider the Indian patent. So if I want to file a patent in US, then I have to separately go and follow their legislation and file a patent there. So this right is called territorial. So this right is, suppose I file in India, I get a patent here for 20 years. The invention is mine only in India. Somebody abroad can come out with new invention. You cannot, suppose somebody copied your invention and they produced the same invention in abroad, but you did not file a patent there. So you will lose the right. Your right is only within India, within the territory of India. So next is invention related to the atomic energy. So this is anything related to atomic energy. You cannot file a patent. So government will intervene in these matters if it is an invention related to the atomic energy. So next, one more thing, who can file a patent? Who can actually file the patent? So first is true and the first inventor or his assignee or legal representative of any deceased person. So they can file a patent. He should be the actual inventor or true inventor or his assignee. So what is the difference between the inventor and the assignee? So you must know this. So inventor is a person who has contributed to the claimed invention. He actually worked for it. He worked day and night, and he came out with this product or process. So it is his idea. Then next is who is this assignee? So assignee is not interested in the invention, but he is interested in the ownership rights, okay, or the legal rights for the patent. So for example, you suppose I am an inventor, I am working in this college. So I am the inventor for this particular invention, but assignee, the college which I'm working, he can become an assignee because I have used his uh, resources which is available in the college. So I have used all the resources available in the college, and I have performed my experiment here. So the assignee may be interested in the ownership because I have used his property. So we should know the clear this in academics especially, it should be very clear what is the difference between inventor and assignee. Any organization and individual that have ownership interest in the or the legal rights on a patent. Inventor is one who is giving actually his time for the invention, or who came out with the inventive process. Then one more is applicant. So these terms are commonly used in this patent field like inventor, assignee, applicant. So you must be able to clearly distinguish this. Applicant is the one who files the patent. Either inventor also can file the patent, or either assignee also can file the patent. So any person who file or a group of institutions who file, they are applicant. So types of the patent application. This is the next topic. So there are different types of patent application. First one is ordinary patent application, conventional patent application, PCT, international application, patent of addition and divisional application. So first coming to this ordinary patent. Ordinary patent application. So in this type, it's a normal application which anyone files within the country without claiming the priority for any foreign application. Like India always follows this first to file system. Whoever files the patent in India, he becomes the first inventor. He becomes the inventor for that particular invention, and he is the one who can claim the priority. Claiming priority means what? Suppose today is 4th July 2022. I filed a patent today. Maybe it's a provisional or complete. I have filed the patent application today. It is my right. I can claim the priority over the invention. So it's a priority right. It's a claim. I can claim the priority. It is my invention. So this claiming priority is very important concept, and it is multiple times used. So for July 2022, if I filed the patent today, the filing date is also 4th July as well as priority date. The date on which the invention was revealed to the application was filed. So it starts with your protection. It is just to protect your idea. So ordinary patent application, usually you file it without claiming the priority in the foreign country. So here you are claiming the priority only within the country, but not outside the country. So such type of applications are called as ordinary patent application. So usually this patent application should be supported by either provisional specification or complete specification. So I will explain this in the coming slide. So next type of application is conventional application. So what is conventional application? Conventional application is the one which entitles the applicant to claim priority in all the convention countries. So first question here you can ask is claiming priority. I told earlier. Suppose I'm an Indian, I filed the patent in the patent. I filed the patent at the patent office by giving an application. Today I claim the priority. Now you can get the priority by filing conventional application in other countries as well. So there is a procedure for it. Such applications are called as conventional patent application. So this conventional application, it is so convention countries. This is very important. Who are these convention countries? So Paris Convention Treaty for the protection of industrial property was signed in the year 1883. So this treaty was signed by many countries. So now approximately there are 193 countries who are the member of this Paris Convention Treaty. So here you can suppose you file in India today, and within 12 months you can file the patent in any of these countries by claiming the priority. So I can explain you this with an example. So suppose Robert is a person who filed patent application in India. So on 15th July 2005. So basic application and 15 July 2005 is a priority date. Basic application and 15 July. So basic application is nothing but the ordinary application that is supported with the complete specification or provisional specification. So the priority date is 15 July 2005. Now Robert can file the application in the convention countries within the 12 months from the 15 July 2005. From July to the next year July, he can file this application in any country. So suppose if I want to file patent in Japan, because my invention is having lot of monetary benefits, commercializing benefit in Japan. So what I will do? I can go through conventional route because India is also a convention country, Japan is also a convention country. So Robert, see, he has 12 months time from 15 July to 2005 to file the application in any of the convention country. So applications filed in other convention countries are called as conventional applications. And priority, the important thing is that the priority date of all applications in such case shall be 15 July. Now, 15 July he filed in India 2005. Then after 2 months, he is filing the application in July, August, September. He filed the application in Japan. So during that 2 months space, actually he entered Japan lately, but he can claim priority of 15th July 2005. So this is actually, these dates are very, very important when you are doing prior art search. Okay, this priority date is like before this particular date, it proves that your invention is not revealed to the public. That's why priority date is very, very important. So next is international patent. International patent, okay, so that is patent cooperation treaty. So or it's a treaty which is signed by 155 states. So there are 155 contracting states that have come together and have signed this treaty. So see, international patent is not that if you file a single patent and you can get the patent all over the world. No, it is just a mechanism to enter into the foreign countries. It is just a mechanism or a route to enter into the foreign countries. So suppose I have created one invention and that has got application in 10 countries. So what I will do? So individually, if I file an application in all these convention countries, it will be a very costly affair for me. Monetary wise, or even it is tedious job. So better is what I will go for this international patent application. That is one single application I file. Then when it enters the national phase, I get the I file in the country whichever I want. So this international patent, it is a huge topic to discuss. So I think for now, this is sufficient. You have to remember is that, so this type is just a mechanism, it's a pathway, okay, for entering filing the patent in many countries. Next is divisional patent and patent of addition. So what is divisional patent? As the name says, divisional patent. So as per the Patent Act, okay, any invention should maintain the unity. Okay, it should involve one single inventive step. That is very, very important. It should involve one single inventive step, and that is called as unity of invention. Now, during the examination, the examiner in the patent office found that this invention involves more than one inventive step. So multiple inventive steps cannot be present in one single invention. So in this case, the examiner will guide the applicant to go for divisional application. He will tell split this application, and first invention will be in the first application, and the second inventive step you have to file a separate application for it. So such type of applications are called as divisional patent. So patent which contained two inventive steps have been divided into two separate patents. Then next is patent of addition. Suppose I have designed as I have come up with some invention, and after few years, so I feel like I need to improvise this current invention, or there is possibility of improvising the idea or the invention. I come up with a new, I get a better version of it, better improved invention. So it is additional to the already, it's addition of the currently existing invention. Such type of inventions are called as patent of addition. An application for patent in respect of any improvement or modification or improvement. Both these concepts are involved. Next, steps involved. So yeah, steps involved for a process of filing patent. This is also very, very important. Which are the different steps? So first we'll see that first, before filing the patent, we should carry out the patentability search or prior art search for the inventions that for our invention, as we know completely our invention, but there are many people outside who are also working in the same technology or same area. So what is in your mind may also be going in their others' mind, as well as they may have proved the result also before you. So before filing a patent application, you have to carry out the prior art search to check whether it will meet the criteria of patentability, whether the invention is novel or whether the invention has an inventive step or it is having industrial applicability or it is not falling under any it is not matching any clauses of Section 3 or Section 4 of the Patent Act. So patentability search is not mandatory, but it is always better to carry out a patentability search for any invention before filing of the patent. Before drafting, if you go to any patent agent, first he will tell you that first carry out priority search if you are interested. Then further we can go for the drafting of the application. So second step is drafting of the patent application. So either the inventor can draft the patent application by himself or he can approach any patent agent. So there are two types. So patent application is always accompanied by provisional or complete specification. Provisional, what is it now? What's the difference between provisional and complete specification? Provisional specification will give the brief description of the invention or disclosure, whatever the invention is, it will be disclosed plus title of the invention. So this provisional application is filed when the invention has not reached the final stage. Still some work is pending or you are supposed to work on the invention. So in this case, you are going to file the provisional specification. Your invention have not reached the final stage. So first, what you want to protect this idea. So how you can do? You can protect your idea by filing the provisional specification. Then you will file the complete specification within 12 months of period from the date of filing provisional specification. So what this complete specification should contain? Complete specification should give brief description, the background of the art, as well as diagrams or this abstract, the drawings, claims, what you want to actually protect. Claims is a heart of the invention, we say, and that is enclosed in this complete specification. But in provisional specification, it is not mandatory. But whatever is being put up in the provisional specification, you have to include that in complete specification. Some new concept you cannot add here. But if you are adding a new concept, then the priority for the claim will change. So it is, so from the date of filing provisional, within 12 months, you will have to file the complete specification. You will have to remember this much. The provisional application need not contain the claim, or it is mainly filed when the invention is not completed. So you will get, once you file provisional, you will have a time period of 12 months. You can file within next 3 months, next 4 months, next 5 months, or within 12 months, anytime you can file this complete specification. But if you fail to file the complete specification within 12 months or by latest by 12 months, then your application is abandoned by the patent office. It is not at all considered. Next is filing. First filing. Always it is better to first file the invention in India. If interested in protect your invention in forest jurisdiction, within 12 months, you will have to go for conventional application or PCT application. So I told that earlier. Conventional, so in India, first you are filing and you are getting the priority date, okay, or the date you are fixing. So this date has a lot of value. So first you file in India and you have 12-month time period to go for conventional application or patent cooperation treaty application, PCT application. Next, so if you don't want to go to foreign file in India first, you want to directly, before that, these applications have to be, what are the forms? Okay, what you have to submit to the patent office before the patent office. So you will have to give first the form 1, that is application for the grant of the patent. Form 2, which involves provisional and complete specification, statement and undertaking regarding the foreign application under Section 8, declaration as to inventorship, and forms for authorization of the patent agent, and Form 28 to be submitted by startup or small entity. You decide to file a patent today. These are the documents that you are supposed to give to the patent office. So Form 1 is nothing but it's a basic application which contains basic information regarding you, which type of application it is, your details, inventor details. Suppose it is filed by the assignee details. So application, it is just application form. Now provisional and complete specification. There is a format to write the provisional as well as complete specification, and this format is given in Form 2. Okay, Form 2 of the Patent Act. Then along with this Form 1 and Form 2, Form 3 has to be given. That is statement and undertaking regarding foreign application. You filed a patent application today. Now you are giving undertaking and a statement that suppose you are to the patent office that if any further I will file in a foreign country, I will inform the patent office. So this is just you are giving an undertaking. Whatever I'll proceed further with, I'll make with the whatever I come out with the application, I will be informing to the patent office. For this, Form 3 is important. Then next is declaration as to inventorship. So this form is actually sign of the specifies the name of the inventor. Then Form 26 for the authorization. You are not drafting or you are not making the patent application and you have approached the patent agent. In this case, you will go for Form 26. Lastly, Form 28 to be submitted by startup or small entity. So these are the documents that you will have to submit to the patent office at the time of filing. So next is, can I file the patent directly in the foreign country? So yes, you can file the patent directly in the foreign country without filing in India, but you will have to get the foreign filing license for this. But you will have to get a foreign filing license. How do you get it? So you will have to disclose the invention to the Indian Patent Office first. You will have to take permission and you have to get a license. So for this, you will have to make application in Form 25. You will have to request to Patent Office by disclosing your invention to Patent Office in the Form 25. So Indian Patent Office grants permission within 21 days if only the invention is not related to the defense or atomic energy. The invention should not be related to the defense or atomic energy, or else the government will intervene. If it is barred or it is cleared from the Patent Office, it will give you the permission. Next is alternatively how you can file. So first, alternative option. If you don't want to go for this foreign filing license, first you file a patent application in India, wait for 6 weeks. Minimum 6 weeks you will have to wait. So even the government, so no secrecy direction from the government. So they will wait. Once you file 6 weeks, they will, if there is any problem with the application, if the related to the secrecy of the government, then if it is, it should not be any secrecy directions from the government should not be there. Then you can file directly to in the other countries. But thing is, you wait for the 6 weeks and wait for the green flag from the patent office. This is one more option, or get the foreign filing license. So next is publication of the patent applications. So publication, once you are filing the application, the patent application will be made public after 18 months. So Indian Patent Office will publish patent application ordinarily after 18 months. So if you are not making any request to the patent office, directly it will be published after 18 months. If you want the application to be early published, you can make a request by giving a Form 9, filling a Form 9 and requesting the patent office to publish your application fast within. So once today I am filing the request form, then within 1 month of my request, the patent application will be published. Next, so under what conditions the applications will not be published? Usually this publication will happen in the patent journal on every Friday. So if you go to this page, this patent office website, you can check on every Friday which are the applications gets published, which have been filed before 18 months. So under what conditions, okay, this patent applications are not published? Suppose secrecy direction have been imposed under the Patent Act. Means government has asked the patent office to keep the invention as a secret. It should not be exposed to the public. Or suppose you have filed a provisional application, but you did not file complete specification. Then also the application will not be published. So complete specification is it's a very important. Without filing complete specification, you have filed provisional, but you have not filed complete. Then your application, it won't be published and it is abandoned. So in this case, it won't be published. Then somebody, see, this patent office will also give you the opportunity to withdraw. Suppose you want to withdraw the filed application. So you can withdraw it within 15 months from the date of filing. Then in such cases, for this we'll have to make a request by giving form 29. But once you give the request for withdrawal, even then the patent office will not publish the patent application. Next is examination of the patent application. So examination of the patent application, you will have to make a request for examining your report within 48 months from the date of filing. This is very, very important. 48 months. These timelines are very, very important. From the date of filing provisional application, within 12 months, you will have to file complete specification. From the date of filing the application, within 18 months, the application will get published. So if you want your application to be examined, you will have to make a request to the patent office through form 18. For everything, you will have to give a form. Every request, requesting to the patent office, you will have to give it. So if you want your application to be examined, then you will have to make form 18 and put a requisition there. Please, you have to request for an examining. So, and there is a timeline. Today I filed within 48 months. I will have to file this request for examination, or else again my application will be abandoned. It won't be considered after 48 months. Today I filed, within 48 months, I have time period of this 3 years approximately. So within that, I have to file the request. Without giving the request for examination, your application will not be examined. So this is one thing. Then, see, some people are not interested to wait for 48 months. So in this case, also government gives you the provision, okay, for fast tracking. That is, patent application can be subjected to expedited examination. Like you don't want to wait for this long queue. So what you will do? You will file form 18A. So form 18A, you can ask the patent office to examine your application immediately. So who can file this request for examination? This is one more important. Inventor himself or interested person. So interested person or inventor himself can file the request for examination. Inventor himself, yeah, it makes sense. But how interested person? See, whenever any product is released into the market, there will be competition between the many companies. So you are working in one technology, and that person has seen, as it is published, he has seen that your invention. So what he does, he wants to know what is in this patent application, because you are his competitor. So the interested person who is working in the similar technology like you, even he can file the request for examination. So instead of you, the opposite person, like the interested person, can also file the request for examination. So this process, this examination process, is a little lengthy process. So once the examiner will examine the patent, so he will issue the examination report. So in this examination report, he will raise the objections. Like he may tell that your invention is not following, it's not coming, it's neither novel, or it is not having an industrial application. So what you should do? You should find the grounds, okay, to overcome the objections that the examiner placed. So applicant needs to overcome the objections that is raised by the examination in the examination report. Then the total time from the day once your FER is been released. So from that time, you will have total 9 months to finish the entire process till the grant. Once you receive this FER, from that within 9 months, this whole process has to be completed. Initially it is 6 months, but you are not able to justify objection. You can take additional 3 months, and within 9 months, at the max 9 months, you will have to overcome all this objection, and you should prove to the patent office that no, all the objections are satisfied, so you can grant a patent. So this process, from once the FER is issued, within 9 months, all this process has to be get over. But if you are not replying to the examination report, even then your application will be abandoned. If you are not replying within the specified period of time, then your application will be abandoned. It won't be considered. Next is final decision on the grant of the patent. Once all the objections raised by the examiner in the first examination report, it is been solved, okay, or all objections you have met. So, and the examiner is satisfied, then they will give a decision on the grant of the patent. Then next step is renewal. Though you have got a patent, so you will have to renew it every year until the time period, total 20 years. So today I'm filing a patent. So up to 20 years, coming 20 years, I have the rights, but I will have to renew it. Just like a renewal fee, okay, you will have like yearly you pay your house tax. So similarly, you will have to pay the renewal fee until it expires. Today I filed, I have 20 years period of time. After 20 years, it is going to expire. So for 20 years, it is my property now. Once a patent is granted, it's my property. From the day it is published only, it becomes your property. But from the date of filing up to 20 years, this period is very, very important. So if you are not renewing the granted patent, if you are not renewing your application, then again the patent granted also will be lapsed. So that will be lapsed. That's a separate thing. You can restore it. But if you are not paying the renewal fee, it will be lapsed. So this is the cycle, just what happens. So first filing of the patent application. If you have, or if you are going with a provisional application or with a complete specification. If you are filing provisional specification, within 12 months, you will have to file complete specification, or directly you can file the complete specification as well. You have two options. You can file provisional and then you can file complete, or one more option is you can directly file the complete specification. So then it will be published as per the Patent Act within 18 months. 18 months time, both the cases, here the application will be published. Then one more thing, there is pre-grant opposition. So suppose pre-grant opposition is before the grant of the patent, any person can oppose. Once it is published, it is general, it is open to public. Suppose any person feels that this patent must not be granted, he can give the opposition to the, he can file opposition, that is representation, filing representation, okay, to the patent office. Then there will be further process. Okay, next, this is one more thing. Suppose you have filed the provisional specification, you did not file complete specification, then also your application will be abandoned. So once it is published, next is request for examination. So examination for the patentability and the other requirement under the Act. So within 48 months in the Form 18, you will have to file the request for the examination. Then the FER will be issued. So also, if you want to speed up the examination process, you can go for expedited examination by filing the Form 18A. This FER, once it is issued, then you will have to comply with the objections raised by the patent office. So usually it is within 6 months, and you get 3 months plus extra 3 months time to meet the objections. If you are meeting the objections raised by them, you have overcome it, the patent will be granted under the Section 43 of the Patent Act, and it will be published. Then one more is, if you are not meeting the objections within 6 to 9 months, then your application will be abandoned. This is a patent flow chart. So next, this anticipation. Anticipation is one of the very important concept. Anticipation is a ground for invalidating or rejecting a patent because it means that the claimed invention lacks novelty. So this is very, very important in the academic section. Like what we do, we carry out research in the college, but we file research paper. Okay, before, sometimes what happens, the inventor, he feels that he has to publish, he has to come up with a thesis. So that's a mode of publication. You are revealing it to the public. Sometimes unknowingly you may reveal. So we will see this anticipation is nothing but that. So once you are making your invention to the public, then you will lose the priority. So your novelty will go. So your invention will lose the novelty if you are going to publish. So all this matter is coming under the section 13. That is the section 13 of the Patent Act. That is anticipation. So when you are, it is when you say that your application is anticipated. So if the application is previously published in India or anywhere in the world, your research work is published somewhere in India or anywhere else, okay, or related research, then it is called as anticipated. And prior claiming in India, you wanted to file a patent application before you only somebody have filed a patent application relating to your invention. So in that claim also you have lost the priority claiming. You can't claim because somebody else have claimed the priority. So in this case also, we say that your application is being anticipated. Now there are exceptions. So under which this anticipation are not considered. That is given by section 29 of the Patent Act. So applicant must prove that. So what are these exceptions? Suppose you are able to prove that the publication, your invention was published somewhere, but with not your consent, then it is considered as anticipation. It is not considered as anticipation. So if you are able to prove that the application or the invention was disclosed to the public without your knowledge, you did not give consent to it, then it is not considered as anticipated. Second is the applicant must establish that he applied for the patent as soon as a prior art publication came to his knowledge. So usually once the invention is made to public, suppose you have given your PhD thesis viva today, within 12 months you will have to file a patent application, but you should be careful that prior you have not published a research paper. This also becomes very, very important. If the invention has been communicated to the government or any other authorized person of the government, so under these conditions, we claim that the invention is not been anticipated. So it is not coming under section 13 to the government or for the benefit of the government. You have disclosed to the government. Then also it is not coming under anticipation. Then one more is you are disclosing it to the peer group. So some conference you are going, during that time you are going to describe your invention, whatever research work you have done. So you have disclosed it for sharing of the knowledge. Okay. So such disclosure also is not considered as anticipation, but it is always better if you have done such things. It is always better to claim or you have to file the patent application within 12 months of such public display to prevent labeling of the claim as an anticipated claim. So it is always better once you disclose the invention to the public, within 12 months you file the patent application regarding your invention. Then last one is opposition proceedings in India. So opposition. So once the patent is being filed, one way of opposing the patent is just after the publication. That is called before the grant. Just after the publication, before the grant. And one way of opposing is after the grant of the patent. So pre-grant opposition is nothing but you are opposing the patent application soon after its application, soon after its publication, soon after its publication. You can oppose it. So always it is preferable that within 6 months of the publication, if you oppose it, is always well and good. Anytime before the grant also you can oppose, but best is 6 months immediately after it has been published. It is called as pre-grant opposition. Then post-grant opposition. Post-grant opposition is you are opposing the patent once it is granted. You are opposing the patent once it is granted. So, but this opposition has to be made within 1 year from the date of the grant of the patent. Within 1 year of the date of the grant of the patent. This is a basic difference between the pre-grant opposition and post the grant opposition. So what are the grounds you can use under which you can oppose the patent application? So first one is wrongful obtainment. So the invention was wrongfully obtained. It is not your invention, but you have taken the invention from third person without his knowledge. So that also can be the ground of opposition. Next one is prior publication. The invention has been priorly published somewhere without your knowledge or with your knowledge. Even see all these academicians will usually file the, I mean, they will make the research publish and they the research papers and they want to publish it. So if you feel that your invention is very good, it is having a very good potential, then I request you all first file the patent and then publish it. Either at least file provisional application and then go for publication. So any form of publication may be considered as grounds of opposition, or it's considered as anticipation as well. Suppose you are very much interested and you want to disclose your invention to the public. This happens especially in students. They have very good idea in their mind, but what they do, they make a YouTube video and they publish it, or they post it on YouTube. So what happens? You are giving the knowledge to somebody else. Now you are making it as a prior art. So before it, always file a patent application if your invention has that much value. If you feel that your invention is potential, then first file the patent application. Next is prior claim. Prior claim is what already somebody have filed the patent before you. They have claimed the priority for the invention. So in that case also, that also can become the ground of opposition. Next is prior knowledge or use. So already it was known to the public. Suppose I have filed a patent application and seeing the, once it is published, some X person may come and it, I already know about it. And I can carry out this, whatever invention is used, I can replicate it. So already it's in use, or third party can easily come and do the same invention. In that case also it is, it's a ground for opposition. Then obviousness. So we can say obviousness is like frivolous, like anybody can do it. So such inventions are also, if it is been filed, anybody can oppose it. Like it's easy to get the result. Even I can do it. Any person skilled in the art can come out with this invention. So under that ground also, I can oppose the patent. Then if the inventions comes under this non-patentable subject matter. So if suppose if X person finds that this invention is under Section 3 and Section 4 of Patent Act, then also anybody can raise the grounds for opposition. Then insufficient description. Suppose any person, layman person, he can feel that he, or a person involved in working in this field, he feels that this description is not properly disclosed. So as per the Patent Act, when you are drafting the specification, complete specification, all the information or the invention has to be explained in detail in the brief description, or along with the example, we call it as embodiment. So it has to be given in the complete specification very thoroughly. So if the disclosure is also insufficient, then that also can become the grounds for opposition. Next is false disclosure. So it is actually not an invention. You are simply filing a patent. Whatever, while doing the experiment, you did not get the actual result, but you have manipulated it and you have come out with an invention. So the false disclosure. So whatever you have written, it is not true. Then also that can become the grounds for opposition. So one more is traditional knowledge. Traditional knowledge. So invent under like haldi, turmeric, whichever we have derived from our ancestors. So such inventions are also not patentable. Biological matter. So when we are making an invention which involves the biological resource, maybe some type of plants or some type of microorganism, always it is important to report to the patent office regarding its origin. But if such information is also not given in the patent application, then it becomes a grounds for opposition. So I have covered this briefly regarding the opposition part. So thank you. Any questions, please? Yes. If any questions, you can ask. So,
Excuse me, ma'am. Myself,
yes.
Kosindra.
Yeah, pardon.
I have a question, ma'am. You one of the slides you mentioned
Yeah.
that a paper which is already published.
Yeah. Regarding the publication, hello.
Yes, ma'am. Yes, ma'am.
Yeah.
So if a particular thing has to be patented, it shouldn't be published previously, right?
Yes.
Is that mentioned?
Yes.
But sometimes I came across this idea of converting papers which are already published and the possibility of converting that into the patents.
No, if actually as per the law, if the invention is published somewhere, you cannot file a patent for it because the examination authority, when they carry out the examination or searching, if they come across that invention which is exactly similar for what you have filed, then they will oppose it. You can file, but it won't be granted. The questions will be raised against you like that.
Right, ma'am. Even if it is of our own research.
Yeah, exactly. So always what I say is always file a patent and then go for publication. So if you feel that if your invention is valuable, then don't go for publication first. First file a provisional. It is not costly. It will charge you around 1,750 or something like that. It's a minimal amount. So you need not go for publication first. Go for filing first. If you feel that your invention is having very good potential.
Great, ma'am. This clarifies. Thank you, ma'am. Requesting other participants, if you have any queries, please unmute yourself or type in the chat box.
So I'll close this presentation.
Yes, madam. We'll wait for a while if anybody asks the questions. Otherwise, we'll forget about the next formal ending of the session.
So hope I'm clear. If you have any query, you can please raise.
If there is no more queries, Dr. Koslindra, please go ahead for vote of thanks.
Right, Professor. So on behalf of Institutions Innovation Council of Institute of Engineering and Tech, Puttur, and the Department of ECE, I, Kosalendra, the convener of IIC, extend my deepest gratitude to both of our resource persons, Madam S. Gomati Padma Thilaga, Scientist B, Patent Information Center, Tamil Nadu State Council for Science and Technology, Chennai, and Madam P. Ashwini Pai, Assistant Professor and in charge for Student Startup Innovation Policy, SSIP Cell, NIT College of Pharmaceutical Sciences, Bengaluru, for sharing their knowledge in these sessions under the Impact Lecture Series scheme. The session 1 on role of IPR in entrepreneurship and the session 2 titled Patent Law, both the sessions were informative.
Okay, sir, I have a request. So can everyone turn on their video? Just I want to take a click.
I would take this opportunity to thank the Honorable Chairman of the Institute of Engineering and Technology, Dr. K. Ashok Raju Garu, for his unflattering support and confidence in us. He's the backbone of our institution and the guiding force for every new step forward. Thank you, sir. I further extend to express my deep regards to Principal Dr. K. Chandrasekhar Reddy and Principal of SIETK, Dr. M. Janardhana Raju Garu, for being constant motivators and guiding force in all our endeavors. And it is your appreciation that enthuses us in all the efforts. I Dr. PG Gopinath Garu, Professor, Department of ECE, Siddharth Institute of Engineering and Technology. I thank the convener of this event, Dr. P. Ratnakamala Madam, Head of the Department of Electronic Communication Engineering, and also the President of Institutions Innovation Council for her solid support and timely monitoring in every aspect as we grow. Finally, yet importantly, our greatest appreciation and gratitude to the coordinator of today's event, who is the man behind getting the fund for this Impact Lecture series, Dr. R. Prem Kumar, Professor, Department of EC at Siddharth Institute of Engineering and Technology, for his exceptional efforts to bring out this in a well-organized way. And we are expecting further more events from you, sir. Thank you. I wholeheartedly thank the organizing team of this program for the teamwork, continuous effort, and ability that made this event a success. Above all, each one of us at Institutions Innovation Council, Siddharth Institute of Engineering and Technology, is highly thankful and indeed grateful to our sponsor, Ministry of Human Resource Development Innovation Cell, All India Council for Technical Education, ACTE, New Delhi, for all the belief they have in us and giving us this opportunity to conduct a total of 4 sessions, 2 sessions in session 1, which was conducted on 2nd June 2022, and 2 more sessions. I gratitude to all esteemed delegates, participants of this webinar for their presence and enthusiastic participation to make this webinar a great success. I wish all of you a wonderful time ahead. Thank you all.
Thank you, ma'am. Ashwini, ma'am, your presentation really, grateful, and we got, more informative information. Thank you so much for your patience and,
That's really great to hear from
the
you,
interesting to share whatever the information you are learned from, your past experience.
Yeah.
So thank you so much. We will be keep on touch, and we will be, do many more, that upcoming technological oriented sessions in upcoming days. Thank you so much, ma'am.
Thank you so much, sir. Thank you so much for giving this opportunity to share my knowledge with you all. It was indeed a great opportunity. Thank you so much.
Thank you, ma'am. Thank you. So we'll be ending the session. Thank you all, and we look forward for a few more sessions in the future. Good day.